Welcome to NIPT's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nipt.com/law to read the full decision.
People v. Jonathan Rios. Decided February 19, 2026. Troutman. In People v. Lopez, we articulated a narrow exception to the rule that defendants must move before the trial court either to withdraw their plea or vacate their judgment of conviction to preserve their challenge to the factual sufficiency of their plea allocution. The Lopez exception applies where the defendant's recitation of the facts underlying the crime pleaded to clearly casts significant doubt upon the defendant's guilt or otherwise calls into question the voluntariness of the plea. If that occurs, and the trial court accepts the plea without inquiring further, the defendant may challenge the sufficiency of the allocution on direct appeal, notwithstanding that a formal post-allocution motion was not made. Defendant now asks us to resolve a question that has divided the appellate division. Does the Lopez exception apply where, as here, defendant has merely claimed at sentencing that he is not guilty of the crime to which he had previously pleaded guilty? We now clarify that because the Lopez exception arises from a court's duty to inquire further where a defendant's statements prior to entry of the plea cast serious doubt on its validity, the exception does not apply to defendant's post-plea statements made at sentencing. As a result, defendant's argument that his plea was not knowing and voluntary is unpreserved for our review because defendant did not first move to withdraw his plea or vacate his judgment of conviction. 1. The people charged defendant by indictment with 2 counts of robbery in the second degree. Defendant pleaded guilty to 1 count of robbery in the second degree in satisfaction of the indictment. During the plea allocution, defendant admitted under oath that on August 27, 2019, he had forcibly stolen money, lighters, cigarettes, and beer from a clerk at a 7-Eleven while displaying what appeared to be a pistol, revolver, or other firearm. The court accepted defendant's plea and ordered the probation department to prepare a pre-sentence investigation report, PSR. At his pre-sentence investigation interview, defendant said he did not rob anyone. Defendant stated that he robbed the store while doing confidential informant work for a drug task force agent. Defendant also stated that he robbed the store to, as he later clarified, collect money from one of 2 clerks who owed money to a drug dealer. At sentencing, the court questioned defendant about his statements to the probation department. This led to an exchange between the court and defendant where defendant first stood by his statements to the probation department, but also, with his counsel's input, admitted his guilt. The court then proceeded with sentencing defendant. On his appeal to the appellate division, defendant contended that his post-plea statements at sentencing cast doubt on the voluntariness and knowingness of his plea and required vacatur of his plea. The appellate division rejected that contention because defendant failed to preserve his challenge to the voluntariness of his plea by moving either to withdraw his plea or vacate his judgment of conviction. The court held that the narrow exception to the preservation rule that we articulated in People v. Lopez did not apply. A judge of this court granted defendant leave to appeal. We now affirm. 2. Generally, a defendant must preserve a challenge to the voluntariness of their plea by moving either to withdraw the plea under CPL 220.60 or to vacate the judgment of conviction under CPL 440.10, People v. Scott, citing Lopez. The policies underlying this preservation requirement include allowing the development of a full record, fostering the efficient resolution of claims at the earliest opportunity, People v. Paquet, and giving trial courts the opportunity to address the perceived error and to take corrective measures in the first instance, Scott, quoting People v. Lorry, C. Lopez, "The very real interest of the state in achieving finality in a criminal prosecution mandates that such objections be timely raised." We have carved out a narrow exception to this preservation requirement. Under People v. Lopez, where the deficiency in the plea allocution is so clear from the record that the court's attention should have been instantly drawn to the problem, the defendant does not have to preserve a claim that the plea was involuntary because the salutary purpose of the preservation rule is arguably not jeopardized. Piquet, quoting Lopez. We have also placed significant constraints on this exception. For example, in Lopez itself, we held that the defendant waived any further challenge to the allocution, where the plea minutes demonstrated that the trial court, when confronted with statements casting significant doubt upon defendant's guilt, properly conducted further inquiry to ensure that defendant's plea was knowing and voluntary, and defendant failed to express in any way dissatisfaction with the court's remedial action. People v. Lopez, see generally PK. Under certain circumstances, this preservation requirement extends to challenges to the voluntariness of a guilty plea. Despite such constraints, defendant contends that the Lopez exception to the preservation doctrine applies to his challenge to the voluntariness of his guilty plea because his statements at sentencing cast significant doubt on his guilt. Defendant further argues that our decision in People v. Pastor strongly suggests that the Lopez exception extends to his challenge to the validity of his plea based on statements that he made during sentencing. In Pastor, a defendant challenged his plea on the ground that the sentencing court was obligated to advise him of a possible justification defense after reading his statements in the PSR. We rejected the defendant's challenge as unpreserved in part because he had an opportunity to move before the sentencing court to withdraw his plea. We further stated, defendant said nothing during the plea colloquy or the sentencing proceeding that negated an element of the crime or raised the possibility of a justification defense, and therefore, People v. Lopez is inapplicable. This statement has led to disagreement at the appellate division. There is now a split among the departments over whether the preservation exception applies to defendants' remarks at sentencing that cast doubt upon their guilt. Compare People v. Dupree and People v. Gresham with People v. Brown and People v. Anderson. We now resolve this split and hold that defendant's post-plea statements at sentencing challenging the factual basis of his plea did not trigger the Lopez exception to the preservation doctrine. Despite what defendant suggests, we never held in Pastor that the duty to inquire and the exception to the preservation doctrine that flows from that duty applies to post-plea statements made during sentencing. That issue was not before us. Now that the issue presents itself, we hold that statements made at sentencing challenging the factual basis of a plea do not trigger the duty to inquire. Consequently, the Lopez exception to the preservation doctrine does not apply. The Lopez exception is based on the trial court's constitutional duty to ensure, prior to accepting a plea, that a defendant's plea is voluntary, knowing, and intelligent. Where a defendant's factual recitation negates an essential element of the crime pleaded to, the court may not accept the plea without making further inquiry to ensure that defendant understands the nature of the charge and that the plea is intelligently entered. See Lopez. In contrast, after the court accepts a defendant's plea, but before defendant is sentenced, the statutorily provided procedure for challenging the plea is a motion to withdraw the plea, pursuant to CPL 220.60. Inasmuch as the Lopez exception to that procedure arises from a trial court's failure to perform its mandatory duty to inquire further prior to accepting a questionable plea, it does not apply here. As a result, because defendant neither moved to withdraw the plea nor vacate the judgment of conviction, his challenge to his plea is not preserved for our review. 30. Our interpretation of People v. Beasley differs from that of our dissenting colleagues, who quote that decision out of context. This court decided Beasley upon an appeal from a denial of a motion to vacate a judgment of conviction brought by an application for a writ of error coram nobis, People v. Beasley, referring to the application as a motion to vacate a judgment convicting defendant. At that time, prior to the legislature enacting CPL 440.10, defendants could seek to vacate their conviction through a motion for a writ of error coram nobis, People v. Jones. In other words, in Beasley, unlike here, the defendant preserved his challenge predicated on statements made at sentencing by first moving to vacate his judgment of conviction. Consequently, our holding in Beasley does not conflict with our holding today that defendant's challenge to his plea, based on statements at sentencing, required him first to make either a motion to withdraw the plea or to vacate the judgment of conviction in order to preserve his challenge for our review. It was not until Lopez that this court fully articulated the exception to the preservation requirement at issue, which is rooted in a trial court's duty to inquire further to ensure that defendant's guilty plea is knowing and voluntary prior to accepting the plea. We cited both Beasley and People v. Serrano in support of this duty. See Lopez. Notably, in Serrano, which preceded Beasley, we held that before accepting a plea of guilt where the defendant's story does not square with the crime to which he is pleading, the court should take all precautions to assure that the defendant is aware of what he is doing. Our decision in Beasley relied on this duty to vacate a defendant's judgment. See Beasley, citing Serrano. However, the Beasley court did not expand that duty to cover situations in which a defendant merely recants their guilt at sentencing after entering a valid plea of guilty. Quite the opposite. In Beasley, we clarified that our holding is not based solely upon the statement made by defendant at sentencing. Instead, we found that, based on statements made at the plea proceeding, the trial court's inquiry prior to accepting the plea was insufficient to determine if the plea was entered intelligently. Thus, the standalone duty promoted by our dissenting colleagues did not exist at the time of Beasley, and it does not exist now. Accordingly, the order of the appellate division should be affirmed. Order affirmed. Opinion by Judge Troutman. Judges Garcia, Singas, Canataro, and Halligan concur. Judge Rivera concurs in result in an opinion, in which Chief Judge Wilson concurs. Decided February 19, 2026.
Welcome to NYPTI's Decisions on the Go, using AI for over a decade to help you listen to New York State Court of Appeals decisions on the go. After the podcast, visit www.nypti.com/law to read the full decision.